Your Honor. Thank you very much for your kind words. First of all, I have to express how happy am I to be here again for the second time, for sharing with you some of my knowledge about human rights. I'm extremely honored for your kind words, for your gifts, for the way that you always welcome me and my colleagues at this noble institution. And let me tell you that for all of you, the doors of the Faculty of Law of the University of Lisbon will always be open. We would be very happy to have you also the brief time possible. So, as Professor said, I'm trying to explain to you a little bit about the right to life, the concept of the right to life in the European Court of Human Rights. I have to say that all of us share the same doubts, share the same challenges. We have all in common when it comes to define not only what is life, human life, I'm just going to mention human life, but also what are the state duties towards protection of human life. Professor Ghosh asked me just to briefly mention a little bit of a context about the European Court of Human Rights. So we need first to check what is this court, because we don't have a federalism system, so this is an international organization. And the first thing I wanted you to look at is how broad is the number of countries that are part of this European Court. So I'm mentioning the Council of Europe, not to be confused with the European Union, which is a different organization, okay? European Union is an organization aimed at the political and economic cooperation and integration. So I'm mentioning the organization in Europe that is responsible for protecting human rights, which is the Council of Europe. If we take a look, all those in blue are members of the Council of Europe. Unfortunately, Russia is no longer a member. Since its invasion of Ukraine, it was expelled from the Council of Europe, which at the same time is bad because now Russian citizens are not protected under the European Court of Human Rights. All the others, so we are mentioning 46 member states, okay? And we have this European Convention on Human Rights. Since 1950, if you take a look, 2 years after World War II, after the Universal Declaration of Human Rights, so 5 years after World War II, also Europe wanted to create a special catalogue of human rights, so these atrocities would never happen again in the continent. And that's when we created this European Convention on Human Rights, because the majority of atrocities and the war began in Europe. So that's why we have created this convention. And the good things is that all members of this Council of Europe are members to the Convention on Human Rights. It's mandatory. So if you enter the European Council, you are immediately a member to the Convention, and you are immediately bound by the jurisprudence of the European Court of Human Rights. And it has taken this court has been really passionate about the European Court, as you will be seeing during my presentation, because it has expanding so much the protection of human rights in Europe that it has led to many evolutions, to many changes in our legislation. For example, and starting with the right to life, one of the things that the court says is that everyone under the jurisdiction of a member state is entitled to the right to life. I'll explain this with practical examples. There was a very important case where some UK British soldiers were being convicted for having illegally killed some people in Iraq. So during the coalition, where UK and US were occupying Iraq, there were some unlawful killings. So the families of these victims wanted justice, and they went to the UK courts. The UK courts considered that the killings were taken in Iraq, so the UK courts were not competent. So the families were not happy with this outcome, so they complained to the European Court of Human Rights. And you know what the European Court said? It said, well, who killed were British authorities. They carried their jurisdiction with them abroad when they were in Iraq. So they were representing UK. So UK has breached the right to life, even outside the country. Do you see how important it is? Because you see so many atrocities committed outside the country. You have some countries like, for example, US that has created Guantanamo Bay so they could torture and kill outside the territory. So this means that when you are an authority and you move abroad, you are still bound to respect the convention, the Human Rights Convention, or your own constitution. This is such an open door to be responsible everywhere a state acts. Another example, you know that we in Europe have many cases about boats of refugees. So there was this boat that was leaving Libya and trying to enter Italian waters. There comes the Italian Navy, pushes back the boat, putting the lives of the people at risk. It was in the high seas. So Italy said, we are not in Italian territory, so I do not need to respect the human right to life here. The court said, well, you are an authority, even if you are in no man's land, meaning high seas, you are bound to respect human rights of the European Convention. So it convicted Italy for not protecting the lives of these migrants. So as you can see, this is the first thing that we need to bear in mind. These human rights accompany the state wherever the state is acting. Does not matter if it is in the high seas, does not matter if it is under a controlled territory. So even during wars, you are still bound by human rights abroad. So this is very inspiring, this case law of the European Convention. These are the basic rights of the European Convention. If we take a look, there are not that many, which shows that we don't need many rights written. We need essential rights, and we need to extract, this is the position of the European Court, we need to extract maximum protection for each of them. So that's why we have just 14 rights, and we will see that according to these 14 rights, I will only focus on the right to life, we can provide such an effective protection to people. We don't need to write that many things. We just need to understand what is indeed implied on life, on prohibition of torture, on family, and so on. So this was the initial list of human rights, and then there was some evolution, so some other rights were added during a few years later. I'll just call your attention to protocol. Through protocol, so these protocols expanded some rights. I just call your attention to Protocol 6. Protocol 6 abolished the death penalty. This meant first, in 1983, death penalty was abolished during times of peace. In 2002, it was abolished in all times, peace and war. What does this mean? This means that in all the 46 members of the Council of Europe cannot have death penalty. This is completely forbidden. One of the things that we were concerned was that Russia, leaving the Council of Europe, could re-establish death penalty. That did not happen. However, there are suspicions, and the European Court has already convicted Russia of doing an even worse thing, which is executions. Do you know the difference between executions and death penalty? Both reach the right to life, but one is even worse. So death penalty implies a judgment, a trial. Death penalty is a penalty, so it normally supposes a due process of law. You were trialed, you had a lawyer, you could present your evidence, you could even appeal against the penalty. An execution is quite different. You just kill. You just throw someone out of the window. You just execute someone. So it's even more serious as regards both the right to life and also human dignity and the possibility of a fair trial. So unfortunately, some countries avoid being convicted for having death penalty, doing something worse, which is, well, we don't have death penalty, but we execute, which is not even obviously accepted. It is an even worse breach of the right to life. So of course, when we say abolition of death penalty, of course, killings and murders, which are the executions, are also forbidden, of course. So just to mention here briefly, so the European Court of Human Rights has 46 judges, and who are the parties? The individual against the state, or a state against the state. So we always complain about a state failing to protect. One of the 46 member states has failed to protect. So that's what we can do. We can also have a state against the state. For example, there is a very important procedure going on regarding the right to life in the European Court of Human Rights that opposes Ukraine against Russia because of the wars, okay? So Ukraine against Russia. But there are also many Ukrainians that had initiated this procedure. So you can have both state against state, or the victim, or in case of the right to life, the family members of the victim against the state. This is an adversarial procedure, meaning that these parties are in an equal basis, both individual and the state, and the 46 judges do not represent their states. They are independent. Okay, normally they do not decide the cases against their own state. And the decisions are binding. So this is an actual court that will control whether the states are actually respecting. One of the things that I also have to say is that the European Court has been willing so much to protect the rights, all of the rights, not just the right to life, that he has developed several interpretation techniques. And he's always concerned of providing the maximum efficiency to human rights. To human rights, what does the court do? Human rights should be interpreted at the maximum extent possible to protect the most, and the restrictions should be interpreted as narrow as possible. So in order to have this maximum efficiency of human rights. That's what we have, it's called by the French, the protection par ricochet, the side protection. There are some rights that are not expressly written, but we just develop these rights through those that are written. Moving on then to the right to life. So first of all, let's start with the basics. What is the right to life? Which is the biggest doubt all over. When does it start? When does it end? First, is it a right? Is it a duty? Is it at value or objective value by itself? When does it start? the European Convention, the European conception of human rights is that human life starts at birth, at a complete birth, okay? So before birth, you can have protection of the fetus, but we don't call it human life. We call it intrauterine life. So it's a life that is on the making. It receives protection, okay, but it's not the same protection as the life after birth. So in order to receive the full protection, it has to be done after a complete birth. Before birth, our conception is that the fetus gains more protection throughout time. So in the beginning, we allow in some cases, then each country has its own rules, okay? So the right to abortion is a very sensitive issue still. So we have many differences in the 46 countries, okay? We do not allow the same abortion rights. But the general perception of the European Court, so the general protection that we afford, is that the longest the time passes through pregnancy, more protection is given to the fetus, because he's approaching more to what human life is. So at the beginning, the fetus or the embryo is still far away from a complete human life. But the longer time passes, the longer we should protect him. What do? We balance the rights of the woman, her choice, her health, and so on, with the life of the fetus. And the more the fetus is growing, the more weight we give to the fetus. Okay? So, secondly, I will mention when it ends, because there's a huge debate about it. I'm just going to develop on what is the nature of the right of life. The question is this a right of the individual that we can freely dispose, freely give up, or is it an objective value? For example, do you know what the Portuguese Constitution mentions? It does not mention the right to life. Article 2 of the European Convention mentions everyone, so including foreigners, illegal foreigners, we don't care. Everyone is based on human dignity, so it's universal, has the right to life. The Portuguese Constitution is not written like this. It says human life is unbreachable. It does not mention right to life. Well, this is different, right? So big questions arose. Is the right to life a right, or is it a value that we need to protect at all costs? And this has been extremely tricky because we are discussing euthanasia. If it's a right, I can give up the right. But if it is an objective value, it's not up to me to give up my life, because it does not belong only to me. It belongs to the common society. My life has a value, objective value in itself. The European Court, in this matter, has decided that right to life is a right, because it's enshrined as a right. So this is a problem that is going on the Portuguese Constitution because of the reading. It's life, human life is unbreachable. It does not mention a right. Okay, so that's a discussion that is going on. I will address to euthanasia some moments later. So it begins at birth, and it is a right. And this right is enshrined, like all other human rights, on human dignity. So yes, we also follow the view that it implies more than the mere existence, than the mere mechanical existence. It implies living with dignity, which implies positive obligations from the state. So let's go into some practical definitions. So the European Court has been developing what does life requires from the state. And it requires protecting human life at the maximum extent possible. So this means negative obligations. So the state, there are some things that the state cannot do, and positive obligations, things that the state must do so we can live. First, it's obvious negative obligations are always more easy. It's not to interfere with the right to life. So no death penalty and no executions, I should add, of course. So no kill arbitrarily, no death penalty, but also not to kill arbitrarily, encompassing during war times. Okay, remember the British soldier case? War times, meaning during war times, which are the killings that are accepted? Only in self-defense or during fights. We cannot kill civilians. That would be arbitrary killings. Okay? So the only exceptions accepted or for a state killing would be on self-defense and would be during fights, during war, during a state of war. Also, this is not that obvious. Protecting right to life means that we cannot send a person to a country where we know that this person will be facing death penalty or execution. Okay? You know that first, what the case law would say is that, what the countries would say is that, well, if I'm sending someone to execution, I'm not breaching the right to life. It will not be me. It will be the country that will be killing this person. So there was this major case about a criminal that was being extradited to sentenced to death penalty in the US. And UK wanted to extradite. And the European Court said, you cannot extradite, you cannot expel this criminal because he will be subjected to death penalty. And that breaches the right to life. And UK said, yeah, but it's not me that is going to kill. Still, the views of the European Court are so broad and efficient that it considered that sending someone to be killed is as being responsible for the death as you kill it directly, because you know that this person is being killed. So you cannot send someone to arbitrary killing. So this is so important, and this raised a lot of questions because we surrendered many terrorists to the CIA and we knew that perhaps they were going to be subjected to torture. So we are, according to the European Court, we are so responsible to give away someone to torture or to killings as those that torture and kill directly. Isn't this, do you think that this makes sense? Yes, it does. You are kind of an accomplice, right? If you hand someone to these ill treatments. So no death penalty, no executions, no arbitrary killings in situations where you are at war. You cannot kill civilians, you cannot make targeted killings. So all of this is prohibited, but also you cannot give away someone to a country that will be killing. Okay? Then we have protection measures. So protecting the right to life also implies to protect. And we will see that these protecting measures are very broad. They imply to have laws that protect people against being killed, to have procedures and some material measures to help you live in a dignified manner. So let's start with the negative obligations. As I said, no killings with two exceptions. Self-defense. So one thing that is very debated on the right to life is whether right to life is absolute. There are many scholars that argue right to life is the most absolute right of a person. The European view is that human dignity is the more absolute right, not right to life, because you can restrict the right to life in some situations, and human dignity you cannot. I'll explain. You can never torture anyone under no reason, but as regards the right to life, we have two exceptions where you can kill lawfully. Under self-defense. What is self-defense? You know what self-defense is. So I have to kill to save my life or someone else's life. When I teach to the military, because I give some courses to the armed forces, I have it's always very heated, as you can imagine, because some military officials tend to see human rights as an obstacle to their efficiency. So I always have to say, if you can neutralize the enemy without killing, you should do it. You have to first try to neutralize, because you have to protect the enemy's life at the maximum possible extent. But they tend to see the enemy not as a human being, but as an element that has to be exterminated. So it's very hard to say the enemy is still a human being, the terrorist is still a human being, so his life has the same value as yours. This is very hard to understand. It's easy to understand when we are mentioning innocent people. The tricky about the right to life or the right not to be subjected to torture is when we are mentioning the enemy. It's when we are mentioning the terrorists. That's when we put our respect to life at test. If we do respect the right to life, we respect the right to life to anyone, including the enemy, including the criminal, including the terrorist. It's so easy to give away our emotions and just to kill that person, right? So that's when we see if our country takes right to life seriously, is when they are faced with the most extreme situations. And this arises precisely when you are faced with a terrorist, when you are faced with a serial killer, when you are faced with the enemy. That's when you know, I cannot kill this person arbitrarily. Okay? So this is very hard to teach to those that are dealing in the field every day with atrocities, because they give away their emotions and they want to kill. So what I normally say is that if you can defend without killing, if you can neutralize it without killing, you should try to choose it first. But sometimes it is impossible to neutralize without killing. So self-defense is allowed by human rights law. Also, I'll go directly to the police measures now on suppression of revolt and insurrection. If you have also the human rights courts allow that for extreme situations of a big revolt, of insurrection, that are making menaces with firearms or arms that, weapons that pose lives, others people's lives at risk, police can use measures that also encompass limits on the right to life. However, you have a case there, very recent, 2025, where France used a grenade in a demonstration and killed some people. And what the court found was that the use of the grenade was not proportional to the menace that was happening. Yes, the demonstration got a little out of control, but was not posing a threat to other people's lives. So you can only restrict life if the other people's lives are at stake. Not just merely public order, not just merely some disturbances. So if the other people, the general public life is not being menaced, you cannot use these lethal weapons. So France was convicted this year for using grenades to control a demonstration. So there's a proportionality judgment that you need to do here. During war, of course, during war you kill, right? But again, here you have to respect international humanitarian law, meaning no civilians can be killed unless, well, international humanitarian law allows for some degrees of what they call collateral damages. I don't like at all this expression. Yeah, it's utilitarian. You know, that's what they use when they kill civilians. Collateral damages. We are talking about the right to lives of the persons. Again, people with dignity, how can you mention damages for when you're talking with such an important thing? And you tend to, it becomes like a very, well, it was just collateral damages. No, it was not just collateral damages. Under this name, we have committed not only direct atrocities, but indirect atrocities. We did not take good care of our due diligence by killing children in schools, in hospitals, and so on, because of human errors. So we have to be very careful. That's why I don't like this expression. It tends to penalize what happened. No, there was actually lives being lost. It's not collateral damages. We can mention collateral damages when we damage a building or cars, not when we are taking lives of people. So yes, we allow for humanitarian law allows for some civilians' lives being lost, has an inherent part of the war, but they have to be shown that the due diligence were taken care of, and only it was not on purpose, and all the duties of diligence were observed. Then it's lawful, otherwise it is not. So, negative obligations, no killings. State cannot kill, and state cannot send anyone to be killed, either by death penalty, either by extrajudicial killings or executions. Now let's go for what positive obligations do we have. So the state also has a duty to protect our lives. And the first thing, there you have the Portuguese criminal code or penal code. It seems obvious, but the first things that the state needs to do is to incriminate your homicide. If we did not have the crime of homicide or murder, perhaps we would be killing more. We would be giving to our emotions. So it is a positive duty to protect the right to life, to severely punish those who kill each other. In this case, it's not the state that is killing, it's privates killing each other. But the state cannot, we cannot have a state, any state in the world, that allows for this, including direct justice, including making justice by my own hands, which is different from self-defense, as you know. Self-defense, there's an imminent danger of losing lives. Making justice on my own hands is when I retaliate against someone by killing them. So this has to be incriminated. A state that does not punish severely, it has to be a severe punishment, is not protecting the right to life of its citizens, because it's not deterring people for killing. It's what we call general prevention of crimes. Then, other legal measures. This is a very interesting one. It's a very practical one. This was a case, this road safety case. This was a case against Croatia, where Croatia did not have good road safety rules. So this was this road where people could drive very fast with speed and did not have enough road signs. So what happened? A car accident. People died in the road. And they claimed, well, Of course, there was domestic procedures regarding punishment of those drivers, but at the same time, the family of the victims claimed that the road was not proper, that the road was not built in order to allow you to circulate with safety. So the state was convicted for breaching the right to life, for not protecting the people on that road. Is that interesting? Like, right to life also demands road traffic rules. Such a practical thing, right? So, yes, because you can be killed, and you know that car accidents is a very easy way to die. So, it's something that you cannot prevent. Every time I take my car, I'm very serious about it. I know that I'm playing with fire. So at least the state has to do its own part, which is road safety rules. Then we have hospitals. We have positive obligations first to have, this is something that in Portugal is being developed, which is the right to life implies a national health system. So positive obligation to have health system. And in the hospitals, the rules have to be, some rules have to be set forth in order to have appropriate standards, meaning hygiene, meaning security, meaning that proper training of the medical doctors. So all these rules in the hospitals are also enshrined in the right to life. We were convicted, we Portugal, in 2019 because it was proven that someone died because some rules in the hospitals were not proper. So she died from contamination, and this was the state failing to provide protection in their own hospitals. Now moving to other types of positive obligations, procedural. First, investigating deaths. We have these not only deaths that were occurred between private people, but also deaths that have occurred when people were at the hands of the state. So there was this Hungary case where an elderly person died in a social care home and the state did not open an inquiry. So we need to know when people die in care homes, in prisons, when they are at the hands of the state, we need to open inquiries to know the circumstances of the deaths. Otherwise, the state is failing on the right to life. And also, of course, the killings when they are done by third parties. I'm going to tell you about this case, this Rantsev against Cyprus and Russia. You know that in the early 20s, there was unfortunately many cases of trafficking of women in Europe. And normally these women were trafficked from Eastern European countries, from Russia, Ukraine, to the West, or to other states in Europe. So we have two women. And normally the techniques were the same. So they were told, oh, you will find a job as a modeling or an actress or a singer, and then they would be taken away and be forced to do prostitution. So we have these two Russian women that were kidnapped in Russia and taken to Cyprus. They tried to escape, and the killers, the smugglers, the traffickers ended up killing them. The families decided that they should be compensated, and they appealed to the European Court, both against Russia and both against Russia and Cyprus. Russia, because Russia has not prevented them from being smuggled. and Cyprus because did not prevent them from being killed. Both of the countries were convicted. So here you see how the states are meant to protect. Of course, we cannot, sometimes it was not the state's fault. So normally we just convict a state when we realize that the state failed. There was negligence from the part of the state. If the state has done everything it could to find the victims, to make procedures to investigate, then the state cannot be held accountable. However, in this case, it was proven that both Russia and Cyprus failed completely, were not diligent. Finally, material measures that we need to do to protect life. First, protect people that are in danger of having their lives taken. And this is such an important case. This case, Opus against Turkey, was the leading case in the world as regards domestic violence. It inspired other systems like the Inter-American Court of Human Rights that has done a similar case and has led Brazil to adopt a complete new law on domestic violence. So what happened in this case that then had this ramification throughout the world? We had this woman that was being severely beaten by her husband, but severely. She was in a such condition that she had to receive hospital treatment. And she went to the authorities several times complaining. So first the hospital authorities did not do anything, did not ask why she was beaten, who had beaten her, nothing. And then she went to the police to complain. And the police said what was very traditional among us in Europe as well. Well, that's something between husband and wife, so we do not intervene in domestic cases. So in the end, what happened? She was killed by the husband, eventually, after a severe ill treatment. And her children brought a case against the authorities. Of course, the husband in the domestic order was convicted, but the children were not satisfied just with the conviction of the father. They said, no, Turkish state has failed. My mother asked for protection several times, and the authorities said, did not take seriously at first, and then said that it was just an intimate, a private issue. So the state has failed. The state has failed to protect my mother. And in this, as you can see, it's not that old, 2009, this completely breaking new views case law, the court said, yes, the state has failed. The state has breached the right to life for not protecting that woman against domestic violence. That was such a whoa. Everybody was like in Europe, whoa, this is so new, so important. And then the Inter-American Court in the Americas, in South America, they have a court like this. We don't have it in the Asia continent. We have it in Europe, America, and Africa, but not in Asia yet. Let's see. So they decided, they were inspired, and they convicted Brazil in a very similar case. And Brazil did not have a law against domestic violence and had to adopt a law against domestic violence. So we all know have laws against domestic violence because of this judgment. And what is at stake was the positive duty to protect right to life. Also, we protect right to life. We also convicted on cases of obvious medical negligence, where we thought that the state, the medical doctors did not protect, and also by failing to give health care in prison. So this is other state positive obligations. I'm bringing to finish some special cases. As I said, these are some sensitive issues regarding the right to life. I've already mentioned the first, the right to termination of pregnancy. I have to say that in these 46 states, as I mentioned, there are still differences. So there are discretion. The state gives discretion to the court gives discretion to each state to decide its own abortion rights. However, it balances between the life of the mother and the life of the child. So in some cases, when the mother died because the state did not provide for abortion at an early stage, the state can be convicted. So there was this case where it was obvious that the mother could not carry on with the pregnancy, and the pregnancy was in a very early stage. So what the court does, it balances. And in the early days, the right to life of the mother weighs more than the right of the life of the baby embryo that is not yet human life. So there you have human life and not yet a human life. So you give prevalence to the woman's human life. Other discussion is when people are in coma. Are they still living? Yes. Yes, there is still human life there. The problem is, well, we said in the beginning that human life is not just mechanically being living, breathing and the heart beating. That's not human life. Human life encompasses the full dignity and capacity and self-awareness and all of that. However, we still consider that it shall be protected. So it's up to both the family and what we say leges artis, meaning the science of the doctors, to decide whether to turn off life support or not. So the court here normally does not convict states if the medical doctors decide to turn off. The court considers that the doctors have authority to know better when it's, for example, irreversible brain damage. And if it's irreversible brain damage, the court considers that that life, now it's only a mechanical life. It's just like a machine working. So turning off life support is not considered as breaching human life, because when it comes to brain irreversible damage, then we consider that the right to life is no longer existent. So yes, we can turn off. Discussing whether, and we have so many cases like this case against France, because the parents of the child, which is a very serious case, you had that child that had a car accident, she was connected to life support, and the doctor said, she's brain dead, we are going to turn off. And you can imagine how painful this is for parents. So they were not confirmed. They said, no, we still have some hope. And they went to the court. And they said, France turned off life support and our child was still living. And the court considered she was not living autonomously. Moreover, she was brain dead. So actually, we give it to the doctors, the decision. It's the doctors that know better whether there is still brain activity or not. So if there is no brain activity, if she cannot live autonomously, then yes, we can turn off. We can turn off the life support. So imagine how difficult this is the case. Finally, the big discussion nowadays on Europe all over, euthanasia. Also here, the court said each state has discretion. Okay? We had already the two situations. The first case was this in 2002. There was this person that wanted to die in the UK, and UK did not allow for euthanasia. She wanted to die, but she could not, she could not do it autonomously because she was paralyzed. But she felt like her life was no longer dignified. It was a mechanical life. She said, this is the same thing as being connected to a machine. I cannot walk, I cannot talk, so I want to, my life, I don't feel like I'm living a dignified life, so it's my autonomy, it's my right to choose, and the right to choose is always also part of human dignity, right to decide my future. This is encompassed on the notion of dignity. I want to die. And it was not possible in UK. If the medical doctor would give a medicine, he would be charged for murder. So she went to the European Court and she said, the right to life on Article 2 is a right. Every right has two faces. Right to marriage, two faces. The right to marry and the right not to marry. The right to, for example, to write in a newspaper. If I want, I write in a newspaper. If I cannot be forced to write in a newspaper. So the same goes for the right to have children. If I want, I have children. I cannot be forced to have children, and so on. So the right to life is the same thing. If I want, I live. If I do not want, I don't live. Well, we ended up at the very beginning of our class. Imagine what the judges had to decide. Because there are some cases that are still up to discussion whether the rights have these two faces. Namely, slavery. Can I be a slave if I want? So some rights do not have two faces. Some rights just have one face. And the discussion was whether the right to life had these two faces. Well, the court chose the easiest way out, which was, okay, this is so sensitive that I will give for each state to decide by himself whether it considers the right to life with encompassing the right to live or not to live or not. Meaning, I will not impose, I will not convict states to have euthanasia. Each state decides. The same goes for abortion. Okay? So this and I think it was important because it's a very structural basis of our societies. In some states are prepared to take this step, other states may not be prepared. This was exactly the same thing. It's not our topic, but it's exactly the same thing as regarding homosexual marriage. We already had that case. Two women that wanted to get married and went to the court. And the court said, I will not convict any state to have sexual marriage. Each state will know when it's prepared, when the society is prepared to give that step. So we did it for euthanasia. So we cannot go to the court and ask for euthanasia. We have in Portugal now, very recent, after many declarations of unconstitutionality, an euthanasia law. It was declared unconstitutional over and over again. First because, as I mentioned earlier, our constitution does not wrote right to life, said life is unreachable, so we cannot reach it by euthanasia. Then they changed, the judges at my constitutional court changed their approach and saw, well, we have to balance life with human dignity. That's how we got around it. And we go back to where we started. Life is only meaningful if it allows for living with dignity. Moreover, dignity also implies you to choose your destiny. you to be sufficiently autonomous to decide how to live. So we have to balance human life, just imagine what are we balancing, and human dignity. And sometimes your life, in these extreme cases that the legislator had to write precisely which cases, can be surpassed if it's being too undignified. The problem was, in which cases does it happen? Because we cannot leave the door open for medical doctors. That's why we have many declarations of unconstitutionality, because the first versions of the law were too broad. Oh, in cases of severe disease, this is not enough, this is too broad. Means that paranoia can, I end up my life if I'm being, this is a severe disease. Schizophrenia. So we had to write over and over again in which cases were so severe diseases that we had to give prevalence to human dignity. It had to be diseases that would take the people completely like a vegetable, like without dignity whatsoever. Moreover, we had to assure that the person was full, with autonomy, full, willing to die. It was not a will that was imposed by the family members. She was not convinced by the family members. It was her own decision. So can you imagine how many times it went to the court and we declared unconstitutional because it was dangerous? Some of the laws would allow for family members to manipulate. Others were too broad. So it had to be incurable diseases, where the person remains full of her capacities to make a full willing to die. Because only then can you assure that it's her project. Only then are you balancing human dignity with right to life. And so we have this very strict law, some call very strict. I think that is better to play on the safe side and to have a strict law than to have too much broad, because we are playing with people's lives and we don't want medical doctors to interpret very broadly when they should kill. Of course, medical doctors remain completely free, as in the abortion, not to do it. So they have the right to refuse. Okay, so nobody is forced to do it. So this is a very hot topic. I will finish with the last hot topic on Europe, which is migration and protecting migrants' lives. When do we have, I mentioned the first case against Italy, the boat of migrants. In that case, Italy has done something that it should not have done. Push back. Push back meaning go back to Libya. Oh, but the boat, we have a problem. I don't care, go back. You shall not enter, because suddenly in Europe, this is the most important thing, we don't know why, is to avoid migrants to enter in the territory. So they were so concerned with this that they wanted to push back and put these people's lives at risk. But in 2022, there was a case against Greece, Safi and others against Greece, the case of 22, that was elected the best and most important case of the year in the European Court. What happened then? There was this boat full of migrants leaving Turkey and trying to enter into the Greek islands illegally. And it was starting to have distress, it started to drown. And so they called for rescue. So we are drowning, you are drowning. The problem is that there is this narrative in Europe now that this is a way, this is a tricky way of migrants to receive asylum. They call for help. Once they are received, they are already in the Navy. The Navy is like the territory of the state, so we cannot send them back. So what did Italy did? What did Greece did not help. So there were many deaths. Many people died because the boat actually sank and people died. In this landmark decision of 2022, the court convicted Greece for breaching the right to life because had not rescued the boat. Isn't this amazing? Like, in the first case, it was just because it pushed back. Now it was because it did not rescue the boat. And this is so important because indeed, European states were not rescuing, they were failing to make rescue operations because they were avoiding migrants to enter in the territory. So this was a strategy. And with this ruling, member states and European states can no longer do this. And finally, of course, right to life also implies protection of refugees. Non-refoulement, it's I don't know whether you know, it's a principle that says that we cannot send refugees back to countries where they are persecuted and also countries that are at war. Well, remember that we cannot send someone back to death penalty, so we cannot send refugees back. So non-refoulement, it's a rule that is enshrined in the right to life, deeply enshrined in the right to life. So this is also because we don't have, if you take a look at the rights that we have in the court, in the European Convention, we don't have protection of refugees, but we don't need. That's the interesting thing about this convention. It has 14 rights, and through these 14 rights, just see what we could protect. We could protect road safety, domestic violence, non-expulsion of refugees, not sending people back to death punishment, rules in hospitals, so many things we have protected only in Article 2 that mentions everybody has a right to life. This single sentence, so small, and allowed the court to make so many, to develop such a broad protection of so many things against trafficking, against domestic violence, so many things that we can take from this so small sentence, everybody has the right to life. So this is what I wanted to bring to you today. Thank you very much.